Your house is paid off. You have the deed in a filing cabinet somewhere, your name on it, or maybe joint with your spouse the way it has been for decades. And you have told your kids, that house is yours when I'm gone. That is the plan. That is the legacy. That is the entire point of 30 years of mortgage payments and property taxes and new roofs and burst pipes fixed at midnight in January. And I am here to tell you with the cold precision of someone who has read every page of the federal Medicaid code so that you do not have to, that the plan has a hole in it the size of a state government. A quiet, legal, fully authorized hole that has been draining middle-class American real estate equity into government accounts for the last 30 years, while financial advisors, bank officers, and estate planners stayed silent. The program is called MERP, the Medicaid Estate Recovery Program. 3 letters. And at Recession Warnings, we are going to spend the next several minutes walking through exactly how it works, why it is specifically designed to catch families off guard, and what the legal structures are that actually block it before it is too late to block anything. Let's talk about Eleanor. Eleanor is not a real person, but she is built from the documented outcomes of tens of thousands of real American families, and what happened to her is happening to approximately 200,000 households every single year across this country right now. Eleanor is 78. She lives in a modest 3-bedroom in a quiet suburb. The house was worth $85,000 when she and her husband Frank bought it in 1979. Frank passed in 2019. Today, the appraised value sits right around $385,000. Not a mansion, not a beach house, an ordinary, fully paid-off middle-class American home. The kind of home that for the entire post-war history of this country has been the primary engine of intergenerational wealth transfer for working families. Parents spend 30 or 40 years paying it off. The house appreciates. The kids inherit it with a stepped-up cost basis. The family moves one rung up the economic ladder. That is the American system. That is how it has functioned since the end of World War II. Eleanor has been showing early signs of dementia since 2024. Her daughter Karen has been quietly managing it, making appointments, taking time off work, driving down on weekends to handle medications and groceries. Then in March, Eleanor leaves the stove on for 9 hours. The fire department responds. And Karen makes the decision that millions of American adult children make every year, standing in parking lots outside memory care facilities with tears running down their faces and a pile of intake forms in their hands. Mom cannot live alone anymore. Mom needs full-time memory care. Memory care in 2026 in most American metropolitan areas costs somewhere between $9,500 and $15,000 a month. Read that again. Between $9,500 and $15,000 a month, that is more than the median household income in 7 states. And Eleanor, like roughly 70% of American seniors, does not have long-term care insurance because when she was 55 and the premiums were still manageable, nobody told her she would need it. And now at 78, she is uninsurable. So Karen follows the social worker's guidance and applies for Medicaid. And here is the moment. This is exactly the moment where the trap closes. The caseworker at the state Medicaid office reviews the application, looks at the bank accounts, looks at the house, and delivers the words that have lulled hundreds of thousands of American families into a catastrophic false sense of security. The caseworker says, "The primary residence is an exempt asset. You do not need to sell the house to qualify." Karen exhales. She calls her brother. She says the house is safe. They told me it's exempt. Mom can get the care she needs, and we keep the house. And that, right there, is the lie. Or to be precise, because words matter enormously in this context, that is the catastrophically misleading half-truth that state Medicaid offices across this country are technically authorized to deliver. Because the full sentence, the part that does not get said out loud, the part that lives on page 47 of the application packet in 8-point font, reads like this. The primary residence is an exempt asset for the purpose of determining eligibility while the beneficiary is alive. Upon the death of the beneficiary, the home becomes a recoverable asset under federal law, and the state is legally required to pursue recovery of all long-term care expenditures from the estate. You see what happened there? They did not technically lie. They told you the first half of the rule and waited for you to draw the wrong conclusion from it. And on that half sentence, hundreds of thousands of American families have made the most expensive estate planning mistake of their lives. 2 years pass. Eleanor is comfortable. The memory care is solid. Karen visits every Sunday. Eleanor passes peacefully in February of 2028. The funeral is small. The family gathers at the house. It is still in Eleanor's name, the way it has been since 1979. 6 weeks later, a certified letter arrives. Return receipt requested. From the State Department of Medical Assistance. Inside is an itemized statement. 22 months of memory care, prescription coverage, medical transport, physical therapy, nursing visits. Total balance owed to the state, $260,800. Pursuant to federal law, 42 USC Section 1396P, the state is filing a claim against Eleanor's estate and a lien against the real property. The family has 90 days to pay in full or arrange a sale. Karen sells the house. After realtor fees, closing costs, and the lien, the two kids split $36,000. 40 years of mortgage payments, 40 years of property taxes, 40 years of repairs and maintenance and equity accumulation, vacuumed straight into the state general fund. That is not a tragedy. That is a system working exactly as it was designed to work, and the people who designed it knew that most families would never see it coming. If what I just described made your stomach drop, if you just mentally checked whether your own deed is sitting exposed in your individual name, if you thought about your own kids for a second, stay with me because I am going to show you the full architecture of this system, the 3 layers of the trap, and the specific legal structures that neutralize each layer. But right now, do one thing. Hit that subscribe button and turn on notifications for recession warnings, because we are building a permanent public record of every mechanism the financial and legal system uses to quietly drain equity from American retirees. And the next enforcement cycle is already underway. Now, there are 3 distinct structural layers to the Medicaid Estate Recovery Trap. 3. And each one is independently capable of stripping your family home from your heirs. Understanding all 3 is the only way to build a defense that actually holds. Layer 1 is the exempt asset deception, and we have already introduced it through Eleanor's story, but I want to go deeper into the legal vocabulary because this is where the confusion begins, and the confusion is not accidental. When the state Medicaid office tells you that your primary residence is exempt, they are using that word in a precise, narrow, technical sense that applies exclusively to the eligibility determination phase of your application. Medicaid is a needs-based federal program. To qualify for long-term care coverage, you must demonstrate that you are effectively broke. In most states, the countable asset limit is $2,000. $2,000. If you have $2,001 in your checking account, you are denied. So if the house counted as a countable asset, no American homeowner would ever qualify for Medicaid because the home's value alone would disqualify them by a factor of 100 or more. The system, in order to function at all, had to carve the house out of the eligibility math. That is the entire scope of what exempt means in this context. We will not count your home against you when deciding whether you are poor enough to receive benefits. That is where the exemption ends. It does not mean the house is protected. It does not mean the state has agreed to leave the equity alone. It means only this: the existence of your home does not disqualify you from receiving care. The state will provide the care. The state will pay for the care, and the state will maintain a precise, itemized, indexed running total of every single dollar spent on your behalf, tracked under your Medicaid beneficiary number, sitting in a database that feeds directly into the state recovery unit's intake system. Every prescription, every nursing visit, every meal, every piece of adaptive equipment, all of it accumulating, waiting, legally authorized by federal mandate. And I want you to understand the mandatory nature of that federal mandate, because this is the point where comfortable retirees in the comments tell me, well, the state would never really pursue recovery on a modest home. The state has bigger fish to fry. Federal law codified at 42 USC Section 1396P does not use the word may. It does not say states are encouraged to pursue recovery. It says states shall seek recovery. That is mandatory statutory language. Every state in the country, all 50 plus the District of Columbia, operates a Medicaid Estate Recovery Program because federal law requires it. There is no escape state. There is no move to a friendlier jurisdiction workaround that protects you from this, because the federal mandate is universal, and the only variable between states is how aggressively they pursue it above the federal minimum, not whether they pursue it at all. The implementation varies significantly by state, which matters for your specific planning, but the outcome for the unplanned family is identical regardless of geography. In aggressive recovery states, the exposure extends well beyond nursing home costs to include prescription coverage and hospital stays for anyone over 55, even outside of formal long-term care settings. Some states use what is called an expanded estate definition, which means the recovery machine can reach assets that never went through probate at all, including certain jointly held properties and assets sitting in revocable trusts. In states with more limited recovery scope, Keeping the house out of probate through a properly structured transfer on death deed or an irrevocable trust may be sufficient to defeat the claim. But the critical word there is may, because the rules change. They have changed before, they will change again, and you do not want your family's financial future riding on the assumption that the political environment of 2026 will be identical to the environment of 2034. The states that appear protective today have a long history of quietly expanding recovery scope during budget crunches, and state budget crunches are coming with mathematical certainty given current Medicaid enrollment projections. Layer 2 is the MERP execution machine, meaning the actual procedural sequence by which the state converts your home equity into a government reimbursement check. Because for a lot of people listening, this still feels abstract. They're thinking, my kids can just refuse to engage. They can move into the house. They can ignore the letters, right? Here's what actually happens, step by step, and the speed of this process is what should make you furious. The moment a death certificate is issued, in most states, data sharing protocols automatically flag the Medicaid Recovery Unit. The beneficiary is deceased. The recovery process initiates. The unit pulls the running tab every dollar spent going back potentially years and generates a formal claim. Then property records are searched. Bank records are reviewed. Any probate proceeding that has been filed becomes a vehicle for the formal creditor claim. The claim is filed with a statutory deadline attached, and the personal representative of the estate, who is usually one of your adult children with no legal background, a full-time job, and a family of their own to manage, has 90 days to figure out how to respond. Most of them call a probate attorney. The probate attorney, who is typically not an elder law specialist, confirms the truth. The state has a valid priority claim. And unless the family has $250,000 in liquid assets sitting ready to pay it off, the house has to be sold to satisfy the lien before interest compounds the balance further. This brings us to layer 3, which is the trap inside the trap, and this is specifically where the people who think they are already protected get destroyed. Because at this point in the conversation, a certain percentage of listeners have already decided on their solution. They are thinking, I heard the first part, I understand the risk, and my plan is simple. I'm just going to sign the house over to my kids right now. Quick claim deed, Saturday morning, put it in their names, and when I eventually need Medicaid, the house is not in my estate anymore. Clean, simple, done. I need you to understand something fundamental. The federal government anticipated that exact strategy approximately 40 years ago and deliberately engineered a counter mechanism to detect it and eliminate it as an option for anyone who waits too long to execute it. That mechanism is the 5-year Medicaid Lookback period. And it is the single most misunderstood rule in all of American elder law. Here is precisely how it functions. When you apply for Medicaid long-term care coverage, the state caseworker is federally required to examine your complete financial history for the 60 months immediately preceding your application date. 60 months. 5 full years. Every bank statement, every wire transfer, every property record, every gift, every transaction where you transferred an asset for less than full fair market value during that entire window. Any uncompensated transfer they identify triggers what is called a penalty period, a period of time during which you are categorically ineligible for Medicaid benefits regardless of your current financial situation, regardless of how much your care costs, regardless of how urgent your medical needs are. The penalty period is calculated by dividing the value of the transferred asset by the average monthly cost of nursing home care in your state. So if you transferred a house worth $300,000 and your state's average nursing home rate is $8,000 a month, you have just created a penalty period of 37.5 months during which the state will provide you zero coverage. Nearly 4 years without benefits at the precise moment in your life when you need them most, during which your family either pays $8,000 to $12,000 a month out of pocket, depletes whatever other savings exist, or faces the horrifying prospect of a family member going without adequate care because the transfer they thought was clever actually triggered a nearly 4-year disqualification. And here is the detail that makes this particularly devastating. The penalty period does not start running from the date of the transfer. It starts running from the date you apply for Medicaid and are otherwise eligible, meaning the state waits until you are broke, until you have exhausted everything else, until you are sitting in the caseworker's office with nothing left, and then and only then does the penalty clock begin. The transfer you made 4 years ago to avoid this exact scenario is now the reason you cannot receive care at the moment you are most desperate for it. This is the architecture of the trap inside the trap. The first trap catches families who did nothing. The second trap catches families who tried to do something but did it too late or did it wrong. Both outcomes produce identical results from the state's perspective. The equity ends up in the recovery account either through estate recovery or through forced private pay during the penalty period. The 5-year window is the reason that legitimate Medicaid planning, the kind that actually works, is not a last-minute exercise. It is not something you do after the diagnosis. It is not something you do when the social worker hands you the application. It is something you execute with an elder law attorney a minimum of 5 years before you anticipate needing long-term care, ideally earlier, because the actuarial reality of American longevity means that cognitive decline and chronic illness often arrive without a warning letter and without a 5-year runway. Now let's talk about the legal structures that actually work, because this is the part most creators skip. They spend 40 minutes describing the problem and 90 seconds on solutions, which serves nobody. At Recession Warnings, we do not do that. There are 3 primary legal vehicles that have demonstrated real-world effectiveness against Medicaid estate recovery when executed correctly and executed in time. The first is the Irrevocable Medicaid Asset Protection Trust, commonly called a MAPT. This is not a standard revocable living trust. A revocable trust offers you essentially zero protection from Medicaid recovery because you can dissolve it at will, which means the state treats the assets inside it as still available to you. An irrevocable MAPT is structurally different. You transfer the house into the trust. You give up direct control. You can no longer unilaterally pull the house back out. And because you have genuinely and permanently divested yourself of ownership, the asset is no longer countable for Medicaid purposes once the 5-year look-back window has passed. If you fund the MAP today and you do not apply for Medicaid for 5 years, the house is protected from estate recovery because it is no longer part of your estate. It belongs to the trust. The trust has beneficiaries, typically your children, and those beneficiaries receive the property outside of probate, outside of the estate, outside of the recovery machine's reach. The critical caveats: you must retain the right to live in the house as a life estate interest or through a retained income provision structured properly, or you may lose the stepped-up cost basis benefit for your heirs. The trust must be drafted by a qualified elder law attorney who understands the specific rules of your state. A generic online trust template will not accomplish this. A standard revocable trust your estate planning attorney drafted in 2018 will not accomplish this. This requires a specialist. The second structure is the Enhanced Life Estate Deed, sometimes called a Ladybird Deed, named informally after Lyndon Johnson's wife. A Ladybird Deed is available in a limited number of states, including Florida, Texas, Michigan, Vermont, and West Virginia, and it is a remarkably efficient tool where it is legally available. The mechanism works like this. You retain full ownership and control of the home during your lifetime. You can sell it, mortgage it, or revoke the deed entirely without anyone else's consent. At your death, the property transfers automatically to your named beneficiaries outside of probate. Because it passes outside of probate, in states where Medicaid recovery is limited to probate assets, the Ladybird Deed can effectively shield the home from estate recovery entirely with no 5-year look-back implications, because you never actually gave up ownership. You simply arranged how the ownership would transfer at death. If you live in one of those 5 states, and if your state has not expanded its estate definition to reach non-probate assets, a properly drafted Ladybird Deed may be one of the most powerful and cost-effective tools available to you. The operative phrase there is maybe, because the intersection of your specific state law, your specific family situation, and the current political trajectory of your state's Medicaid policy all affect whether this tool performs as expected. The third structure is strategic spousal protection, which applies specifically to married couples and leverages the Medicaid rules around what is called the Community Spouse Resource Allowance. When one spouse enters a nursing facility and applies for Medicaid, federal law protects a portion of the couple's combined assets for the use of the spouse who remains at home, the community spouse. The protected amount varies by state, but generally falls somewhere between $30,000 and $150,000 in countable assets plus the primary residence, which is exempt while the community spouse is living in it. This means that for married couples who plan correctly, there are legitimate legal mechanisms to restructure assets in ways that maximize what the community spouse retains while the institutionalized spouse qualifies for Medicaid without triggering penalty periods. Spousal planning is complex and entirely state-specific. But it is real, it is legal, it is explicitly authorized by federal statute, and it is the reason that married couples who engage a qualified elder law attorney before the crisis often fare dramatically better than those who do not. Now I want to address the most dangerous form of inaction, which is not ignorance. Ignorance is understandable. Ignorance is what happens when the system is designed to prevent you from getting the full sentence. The most dangerous form of inaction is the comfortable assumption. The comfortable assumption sounds like this: my estate is too small for the state to bother with. Or, my kids will just handle it when the time comes. Or, I have a revocable living trust, so I'm already protected. None of those are defenses. They are sedatives. The state does not have a minimum threshold below which it declines to pursue recovery. The state has a statutory mandate and a database and a recovery unit with a budget to justify. The size of your estate relative to national averages is irrelevant to the people filing the lien. Your kids handling it when the time comes means your kids selling the family home in a compressed timeline to satisfy a government lien, while simultaneously managing grief and probate administration and their own financial obligations. And your revocable living trust, the one you paid an attorney to draft in 2015 or 2018 with the understanding that it would protect your assets, offers you essentially no protection from Medicaid Estate Recovery unless it has been converted to irrevocable structure with proper asset protection provisions, because a revocable trust is legally treated as a transparent vehicle. The state sees straight through it to the assets inside. This is not a peripheral risk. This is not a theoretical scenario designed to generate clicks. This is federal law. This is mandatory state compliance. This is happening to 200,000 American families every year right now in 2026. The families losing their inherited homes are not careless people. They are not people who failed to love their parents or failed to plan. They are people who received half a sentence from a caseworker and made a reasonable decision based on incomplete information. And the system that provided that incomplete information was not malfunctioning. It was operating exactly as designed. At Recession Warnings, we are not in the business of telling you that the system is fair. We are in the business of making sure you understand exactly how it works before it processes your family. The 5-year look-back window means that the window to protect your home is almost certainly open right now. The question is whether it will still be open when you finally decide to act. Talk to a qualified elder law attorney this month, not a general estate planning attorney, not the attorney who drafted your will in 2010, a certified elder law attorney who specializes in Medicaid planning and knows your state's specific recovery rules. Get the deed structure reviewed. Get the trust structure evaluated. Get the look-back window assessed against your actual age and health picture. Because the letter that arrived at Karen's house 6 weeks after Eleanor's funeral did not come with a warning. It came certified mail with a return receipt and a 90-day deadline. And by then, every option that would have saved the house had a 5-year expiration date stamped on it. The time to act is not when the diagnosis arrives. The time to act is now, while the window is open, while the look-back clock has not started, while the house is still yours to protect. That is what we do here at Recession Warnings. We find the mechanisms. We name them. We walk through them completely. And we leave you with enough information to make the decision that protects your family before the system makes it for you. If this gave you clarity, share it with someone who needs it. Leave your state in the comments below. And subscribe to Recession Warnings, because this is one video in a growing archive of exactly this kind of information. The next one drops soon, and it is one you cannot afford to miss.